Sir, step out of the vehicle now. This car matches a stolen BMW report.
Officer, this is my home and my vehicle. I'm asking you to verify the plate before escalating.
Hands behind your back. You're being detained for vehicle
No,
theft.
for the record, my name is Judge Calvin Reynolds. This detention is unlawful. Check it.
Dispatch confirmed plate CW9473. Copy. Plate comes back.
It was 2:15 in the afternoon on a quiet Thursday when I, Judge Calvin Reynolds, pulled into my own driveway after a grueling day at the federal courthouse in Chicago. I had just finished presiding over a convoluted racketeering trial, ironically enough, and was looking forward to spending a peaceful evening at home with my wife and kids. I was no ordinary person. At 54 years old, I had dedicated my entire adult life to the pursuit of justice. I grew up on the south side of Chicago, where my parents drilled into me the values of hard work, education, and the courage to stand up for what's right. After graduating summa cum laude from Yale Law School, I spent 15 years as a public defender, then another decade in corporate litigation before being appointed to the federal bench by the president himself. I was known throughout the legal community for my impartiality, my sharp intellect, and my unwavering commitment to constitutional principles. Colleagues described me as someone who treated every case with the gravity it deserved, whether it involved a multi-million-dollar corporate dispute or a simple civil rights violation. I had presided over hundreds of cases, many of them involving police misconduct and racial discrimination. That Thursday afternoon, I was steering my black BMW 7 Series through my upscale suburban neighborhood of Oak Brook. I had purchased the car just 6 months earlier as a reward for myself after receiving a Distinguished Service Award from the National Bar Association. The neighborhood where I lived was quiet, tree-lined, and affluent. I had worked my entire life to afford a home there, and I took pride in the fact that my success had opened doors for my family that previous generations could never have imagined. As I signaled into my driveway, I noticed a police cruiser tailing me. I thought nothing of it initially. Police officers patrolled the neighborhood regularly, and I had always appreciated their presence as a sign of safety and security. I gathered my leather briefcase from the passenger seat and was about to exit my vehicle when I heard the sharp, aggressive sound of a car door slamming behind me. Officer Kyle Henderson had been on the force for 8 years. His personnel file would later reveal a troubling pattern of complaints, most of them involving interactions with black motorists. But on that Thursday afternoon, he was about to make a decision that would change both his life and my life forever. He approached my vehicle with his hand resting on his service weapon, his expression stern and suspicious. I rolled down my window as Officer Henderson reached my car. I expected a friendly greeting, maybe a question about whether I had seen anything unusual in the neighborhood. What I got instead was an aggressive demand to see my license and registration delivered in a tone that immediately put me on edge. I asked politely why I was being stopped, explaining that I had simply pulled into my own driveway. Officer Henderson's response would later be described by legal experts as a textbook example of racial profiling in action. He told me that my vehicle matched the description of a stolen car that had been reported in the area. When I calmly explained that this was my own car and pointed to my house just a few feet away, he became more aggressive. He demanded that I step out of the vehicle immediately and accused me of being evasive. Now here's where I made a decision that would prove crucial to everything that followed. Instead of becoming confrontational, I remained calm and compliant. My years of experience in the courtroom had taught me the importance of maintaining composure even in the most challenging situations. I knew that my behavior in this moment could mean the difference between a simple misunderstanding and something much more serious. I stepped out of my car, slowly keeping my hands visible at all times. I calmly repeated that this was my vehicle and my home, and asked Officer Henderson to verify the license plate number against whatever stolen car report he claimed to be investigating. This reasonable request seemed to anger him even more. He told me to put my hands behind my back and began reaching for his handcuffs. I asked, clearly, what crime I was being arrested for. Officer Henderson's answer would later become a key piece of evidence in the federal lawsuit that followed. He told me I was being arrested for vehicle theft and resisting arrest, even though I had been completely cooperative throughout the entire encounter as he cinched the handcuffs onto my wrists. I calmly stated my name, my position as a federal judge, and requested that he verify my identity before proceeding. Officer Henderson either didn't hear me or chose to ignore what I was saying. He guided me to the back of his patrol car while I continued to explain who I was and asked him to check my credentials. My briefcase remained on the ground next to my BMW, containing court documents that would have immediately verified my identity. My judicial identification card was in my wallet, which was still inside my car. As I sat in the back of the patrol car, I remained remarkably composed. I had spent my career dealing with law enforcement officers, both good and bad. I understood the system better than most people, and I knew that this situation was spiraling out of control based on assumptions and prejudices rather than facts. What I didn't know yet was that several of my neighbors had witnessed the entire encounter and were already making phone calls. Mrs. Martha Higgins, who lived directly across the street, had been tending to her rose garden when she saw the police car pull up behind my BMW. She watched the entire interaction unfold and immediately knew something was wrong. She had lived in the neighborhood for over 20 years and had watched my family move in 3 years earlier. She knew exactly who her neighbor was and what I did for a living. Mrs. Higgins called her husband, who was a retired corporate attorney, and described what she was witnessing. He told her to start recording everything she could see and to call the police department immediately to report what appeared to be a case of mistaken identity. By the time Mrs. Higgins reached for her phone to start recording, I was already caged in the back of the patrolled car. Another neighbor, Robert Vance, was walking his golden retriever when he saw the commotion. He recognized me immediately because his own brother had appeared before me in court 2 years earlier in a civil matter. He approached the scene cautiously and tried to explain to Officer Henderson that he had made a mistake, that the man he had arrested was a federal judge who lived in the house right there. Officer Henderson told Mr. Vance to step back and mind his own business. He said he had a stolen vehicle report and was following proper procedure. When Mr. Vance persisted, explaining that he personally knew the man in the patrol car was Judge Reynolds, Officer Henderson threatened to arrest him for interfering with a police investigation. The situation was about to get much worse before it got better. Officer Henderson radioed for backup, claiming he had arrested a suspect in a vehicle theft case who was now claiming to be a federal judge. His tone suggested he thought this was some kind of elaborate ruse. Within minutes, 2 additional patrol cars arrived on the scene. Their red and blue lights were flashing, creating a spectacle that drew even more neighbors outside to see what was happening. What was happening? By now, I had been sitting in the back of that patrol car for almost 20 minutes. The handcuffs were cutting into my wrists, and I could feel the eyes of my entire neighborhood watching this humiliating spectacle unfold. I had presided over cases involving police misconduct, but experiencing it firsthand was entirely different. The powerlessness I felt in that moment would stay with me for years to come. The backup officers who arrived seemed confused about why they had been called. Officer Maria Rodriguez, who had been on the force for 12 years, immediately recognized that something was off about the entire situation. She approached Officer Henderson and asked for a briefing on what had happened. His explanation was scattered and inconsistent. He claimed he had received a report about a stolen black BMW, but when Officer Rodriguez asked for the specific details of that report, Henderson became evasive. Officer Rodriguez walked over to the patrol car where I was being held. Through the window, she could see a well-dressed professional black man who clearly did not fit the profile of a car thief. I looked directly at her and calmly repeated my name and position. This time, someone was actually listening. Officer Rodriguez returned to Henderson and suggested they verify my identity before proceeding any further. She pointed out that if this man really was a federal judge, they were about to face the kind of legal nightmare that could end careers. Henderson insisted that I was lying, that criminals often made up elaborate stories to avoid arrest. He said he wanted to take me to the station for proper processing. That's when Mrs. Higgins approached the scene with her phone in hand. She had been recording everything she could see from her front yard, and she walked directly up to Officer Rodriguez. She introduced herself as the defendant's neighbor and explained that the man in the patrol car was indeed Judge Calvin Reynolds, who lived in the brick colonial house right behind them. She offered to show Rodriguez her recordings and provide contact information for other neighbors who could verify my identity. Officer Rodriguez immediately understood the gravity of the situation. She radioed dispatch and requested that they run a check on Calvin Reynolds to verify his identity and position. Within minutes, the response came back confirming that I was indeed a sitting federal judge. The dispatcher's voice carried a tone of urgency as she relayed the information, and Rodriguez could hear the concern in her colleague's voice. Henderson's reaction to this news was telling. Instead of immediately apologizing and releasing me, he became defensive. He insisted that I should have identified myself properly from the beginning. He claimed that my behavior had been suspicious and that he had followed proper protocol. Officer Rodriguez knew better. She had seen the dashboard camera footage being recorded throughout the entire encounter, and she knew that Henderson's version of events would not hold up under scrutiny. I was finally released from the patrol car after 35 minutes of detention. As the handcuffs came off, I rubbed my wrists where the metal had left red marks on my skin. I remained composed, but those who knew me well could see the controlled anger in my eyes. I thanked Officer Rodriguez for her professionalism and asked for the names and badge numbers of all officers involved. Henderson made one final mistake that would prove costly in the legal proceedings that followed. As I gathered my belongings and prepared to enter my home, he approached me and suggested that the entire incident could be forgotten if I was willing to overlook what he called a simple misunderstanding. He implied that filing a complaint would be unnecessary and that these things happened all the time. I looked at him with the same steely gaze I reserved for the most egregious offenders who appeared in my courtroom. I told him that what had happened was not a misunderstanding, but a clear violation of my constitutional rights. I explained that his actions were exactly the kind of behavior that eroded public trust in law enforcement, and that I would be pursuing every legal remedy available to me. The neighbors who had witnessed the incident began approaching me to offer their support and provide their contact information as potential witnesses. Mrs. Higgins handed me the video she had recorded on her phone. Mr. Vance gave me a written statement describing what he had seen. Even people who had never spoken to me before came forward to express their outrage at what had happened in their neighborhood. Officer Henderson left the scene that day, believing he had simply made a mistake that would blow over in a few days. He had no idea that he had just set in motion a legal process that would expose years of misconduct and cost his department nearly $1 million. The dashcam footage from his patrol car had captured everything including his refusal to listen when multiple people tried to correct his error. I spent that evening calling my family and close friends to inform them about what had happened. My daughter, who was a first-year law student at the time, was so upset she wanted to drive home immediately. My wife, a pediatrician, was furious and wanted to file complaints with every agency she could think of. But I knew that rushing into legal action without careful preparation would be a mistake. Instead, I did what I had trained my entire career to do. I gathered evidence. I reviewed the applicable laws. I consulted with attorneys who specialized in civil rights cases. I documented every detail of what had happened while it was still fresh in my memory. I knew that if I was going to seek justice, I needed to do it the right way. The next morning, I called in sick to court for the first time in over 3 years. I spent the day meeting with attorneys and civil rights organizations. Word of what had happened began to spread through the legal community like wildfire. Federal judges are afforded certain protections and respect precisely because of their role in upholding the Constitution. When one of them is subjected to the very discrimination they work to prevent, it sends shockwaves through the entire system. Officer Henderson reported to work the next day as if nothing had happened. He filled out his incident report, describing the previous day's events as a routine traffic stop that resulted in a case of mistaken identity. He failed to mention that he had ignored multiple attempts by the suspect and witnesses to clarify the situation. He also failed to mention that he had detained a federal judge for over half an hour based on nothing more than racial profiling. His supervisor, Sergeant Alan Brooks, reviewed the report and immediately knew something was wrong. Brooks had been in law enforcement for over 20 years, and he could recognize a sanitized incident report when he saw one. The basic facts didn't add up. Why would someone steal a car only to drive it directly to their own driveway? Why would a car thief calmly provide identification and claim to be a federal judge? And most importantly, why hadn't Henderson verified the stolen vehicle report before making an arrest? Brooks pulled the dash cam footage and watched the entire encounter unfold. What he saw made his stomach drop. He could clearly see me remaining calm and cooperative throughout the entire interaction. He could hear me repeatedly identifying myself and asking Henderson to verify my credentials. He could see the neighbors approaching to vouch for my identity. And most damning of all, he could hear Henderson's dismissive and increasingly aggressive responses to everyone who tried to correct his obvious error. By Thursday morning, Brooks was sitting in Chief Karen Hayes' office, playing the footage for her on his laptop. Chief Hayes had been leading the department for 6 years and had worked hard to improve community relations and reduce complaints about officer conduct. As she watched the video, she realized that all of that progress was about to be undone by one officer's spectacular failure in judgment. The department's legal counsel was called in immediately. Attorney Michael Sterling took one look at the footage and told Chief Hayes that they were facing a potential federal civil rights lawsuit that could bankrupt the department. He explained that detaining a federal judge based on racial profiling wasn't just a public relations disaster. It was a constitutional violation of the highest order. Meanwhile, I had retained the services of civil rights attorney Jonathan Black, whose firm had won several high-profile cases against police departments across the country. Black reviewed the evidence I had gathered and told me that I had one of the strongest cases he had ever seen. The dash cam footage alone was enough to prove racial profiling. But combined with Henderson's personnel file and the witness statements, it painted a picture of systemic misconduct that had been allowed to continue unchecked. Black filed the federal lawsuit on Friday morning, exactly 1 week after the incident occurred. The complaint alleged violations of my Fourth and 14th Amendment rights, claiming that I had been subjected to an unlawful seizure based solely on my race. The lawsuit named Officer Henderson, Sergeant Brooks for inadequate supervision, and the entire police department for maintaining policies that enabled racial profiling. The filing made immediate headlines in local news outlets. A federal judge suing his own community's police department was unprecedented in the area. Legal experts who were interviewed about the case universally agreed that I had strong grounds for my lawsuit. Professor Linda Torres from the University of Chicago Law School told reporters that the dashcam footage appeared to show a textbook case of racial profiling. Officer Henderson was placed on administrative leave pending the outcome of both the internal investigation and the federal lawsuit. For the first time since the incident occurred, he began to understand the magnitude of what had happened. He hired his own attorney, who reviewed the evidence and delivered some sobering news. Henderson was likely going to lose his job, face potential criminal charges for violating my civil rights, and could be personally liable for damages in the federal lawsuit. The internal affairs investigation concluded within 2 weeks. Investigator Captain Sarah Lewis found that Henderson had violated multiple department policies, including those governing traffic stops, use of force, and professional conduct. Her report noted that Henderson had failed to verify the stolen vehicle report, ignored attempts by multiple witnesses to correct his error, and showed a pattern of targeting black motorists that violated both department policy and federal law. Henderson's personnel file revealed a troubling history that had somehow escaped serious scrutiny. Over his 8 years on the force, he had received 14 complaints from citizens, 12 of which involved allegations of racial bias or excessive force. Most of these complaints had been dismissed with minimal investigation or resulted in minor disciplinary actions like additional training or written reprimands. The pattern was unmistakable. Henderson had stopped black motorists at a rate nearly 4 times higher than white drivers, despite working in a predominantly white district. His searches of black drivers yielded contraband at the same rate as searches of white drivers, proving that his increased attention to black motorists wasn't based on legitimate law enforcement concerns. Captain Lewis's investigation also revealed that Henderson's supervisors had failed to recognize or address this pattern of behavior. Annual performance reviews consistently rated him as satisfactory or above average, with no mention of the citizen complaints or statistical disparities in his enforcement activities. The department's early warning system, designed to flag officers with problematic behavior patterns, had somehow failed to identify Henderson as a concern. Chief Hayes made the decision to terminate Henderson's employment before the internal investigation was even complete. The evidence was overwhelming, and she knew that keeping him on the force would expose the department to additional liability. Henderson was fired on a Tuesday morning, exactly 3 weeks after he had arrested me in my own driveway. Henderson's firing made front-page news, and the story began attracting national attention. Civil rights organizations praised me for my courage in pursuing legal action, noting that many victims of police misconduct lack the resources or knowledge to effectively challenge such violations. The NAACP issued a statement calling the case a perfect example of how racial profiling affects people at every level of society. Legal experts began analyzing the case as a potential landmark in civil rights law. Professor James Washington from Howard University Law School explained to reporters that federal judges occupy a unique position in the legal system, and violations of their civil rights carry additional constitutional implications. He predicted that the case could result in significant monetary damages and might influence how courts handle racial profiling cases in the future. The discovery phase of the lawsuit revealed even more damaging information about the police department's practices. Black's legal team subpoenaed 5 years of traffic stop data, complaint records, and training materials. What they found was a department that had systematically failed to address racial bias among its officers. Statistical analysis of traffic stop data showed that black drivers in the community were stopped at rates significantly higher than their representation in the local population. They were also more likely to be searched, more likely to be arrested, and more likely to have force used against them during encounters with police. Despite these disparities, department leadership had taken no meaningful action to address the obvious problems. The lawsuit also uncovered evidence that Henderson wasn't the only problematic officer in the department. 3 other officers showed similar patterns of racially biased enforcement, and all of them had received minimal discipline despite multiple citizen complaints. The department's training records revealed that officers received only basic instruction on constitutional rights and racial bias with no ongoing education or accountability measures. I found myself in the unusual position of being both a victim of misconduct and an expert on the legal system designed to address such violations. I used my platform to speak publicly about the need for police reform, giving interviews to national news outlets about my experience. I emphasized that if a federal judge could be subjected to such treatment, ordinary citizens faced even greater risks. My case began attracting attention from federal officials in Washington. The Department of Justice announced that it was monitoring the situation and considering whether to launch a broader investigation into the police department's practices. Civil rights groups called for a consent decree that would place the department under federal oversight until meaningful reforms were implemented. The media coverage put enormous pressure on city officials to respond. Mayor Jennifer Clark announced a comprehensive review of police policies and promised significant reforms. She appointed a civilian oversight board and committed to implementing implicit bias training for all officers. Critics noted that these were exactly the kinds of reforms that should have been in place years earlier. As the case moved toward trial settlement, negotiations began in earnest. The city's insurance company, which would be responsible for paying any judgment, pressured officials to resolve the matter quickly and quietly. They knew that taking the case to trial would mean weeks of negative publicity and the risk of an even larger award from a sympathetic jury. I faced a difficult decision about whether to accept a settlement or proceed to trial. My attorneys advised that a trial would likely result in a larger monetary award and might lead to more comprehensive reforms. However, it would also mean months of additional litigation and continued public attention to one of the most painful experiences of my life. The settlement discussions revealed the true cost of Henderson's actions that Thursday afternoon. The city's initial offer of $250,000 was immediately rejected as inadequate. Jonathan Black countered with a demand for $2 million, citing the severity of the constitutional violations and the need to send a strong message about accountability. Negotiations continued for weeks, with both sides recognizing that the stakes extended far beyond money. I wanted assurances that meaningful reforms would be implemented to prevent similar incidents in the future. The city wanted to avoid the spectacle of a trial that would expose years of negligent supervision and discriminatory practices. The case was attracting attention from legal scholars who saw it as a potential turning point in how courts handle racial profiling cases. The combination of clear video evidence, a sympathetic victim, and extensive documentation of systemic problems created what many experts considered an ideal test case for civil rights enforcement. Local activists organized rallies in support of me, drawing hundreds of community members who shared their own experiences with biased policing. The events highlighted how widespread the problem had become and put additional pressure on city officials to accept responsibility and implement genuine reforms. Henderson, meanwhile, had become unemployable in law enforcement. No police department would hire an officer who had been fired for racially profiling a federal judge. He struggled to find work in any field as his termination had been widely publicized. His family faced harassment and threats, and they were forced to relocate to another state to escape the negative attention. The ripple effects of that 35-minute detention continued to spread throughout the community. Other victims of Henderson's misconduct began coming forward with their own stories, some dating back years. A class action lawsuit was filed on behalf of dozens of motorists who alleged they had been illegally stopped and searched by Henderson based on their race. The police department's reputation suffered tremendously. Recruitment became difficult, as qualified candidates were reluctant to join an organization associated with racial profiling. Community trust, which had taken years to build, evaporated almost overnight. Business leaders worried about the impact on the city's image and economic development prospects. As settlement talks intensified, both sides prepared for the possibility that negotiations might fail and the case would proceed to trial. I remained determined to see justice served regardless of the personal cost. I had dedicated my life to upholding the Constitution, and I wasn't about to back down when my own rights had been so clearly violated. After 18 months of legal battles, the jury delivered their verdict in just 4 hours. $910,000 in damages plus mandatory police reforms that would reshape the entire department. Officer Henderson lost everything: his career, his pension, his reputation. I used my settlement to establish a foundation supporting victims of police misconduct. Sometimes justice takes time, but when it arrives, it changes everything. This case was brutal, but it brought necessary light to a dark corner of our justice system. This narrative is a retelling based on a true story, specifically inspired by verified instances of racial profiling involving legal professionals, though all names, ages, and specific locations have been altered for privacy and storytelling purposes. The primary lesson here is the importance of knowing one's constitutional rights and the power of remaining calm under pressure. Judge Reynolds' composure allowed the truth to be captured, clearly proving that reacting with aggression, even when justified, can often obscure the facts. Furthermore, this story highlights the critical role of community witnesses, the neighbors, in holding power accountable. It serves as a reminder that systemic bias is real and that justice often requires not just the law, but the vigilance of ordinary citizens to enforce it.